The Competition and Markets Authority, CMA, was established in April 2014 under the Enterprise and Regulatory Reform Act 2013, ERRA. It regulates the entire United Kingdom and is responsible for strengthening business competition and reducing anti-competitive activities. The CMA is an independent, non-ministerial department. In April 2014, it brought together the existing competition and consumer protection functions of the Office of Fair Trading and the responsibilities of the Competition Commission. GEMA has concurrent powers with the CMA with regard to competition in the energy sector. They work closely together as the ERRA requires any sectoral regulator to consider the impact under competition law before making use of its sectoral specific powers. By virtue of Section 5 of the Enterprise Act, the CMA functions by conducting studies of the functions of competition within a given market in the UK as a whole, rather than conducting investigations on specific actions of companies. When the findings of a market study give rise to reasonable grounds for suspecting that a feature or combination of features of a market prevents, restricts, or distorts competition, the CMA can initiate a targeted investigation. For the CMA to carry out a market-wide investigation in any of the electricity or gas sector markets, OFGEM may refer any of those markets to the CMA, or the CMA may instruct OFGEM to transfer a case. Prior to the UK's withdrawal from the EU, the CMA worked closely together with the European Commission on competition law enforcement and merger investigations across all sectors. Since the 1st January 2021, this has changed and the role of the CMA has been expanded to cover new functions. In December 2020, the CMA published guidance setting out the scope of its functions in detail. In addition to the aforementioned regulators, a key role in Great Britain's energy market is carried out by the following regulators and government departments. The Department for Business, Energy and Industrial Strategy, BEIS, plays a key part in the regulation, organization and management of the energy market. BEIS is a UK government department created in 2016, taking over from the Department of Energy and Climate Change, and is supported by 41 agencies and public bodies. As a result of Brexit and onshore EU legislation, the role of BEIS has been expanded to cover functions previously assigned to EU authorities, and new cross-government working groups have been set up. The Secretary of State is responsible for BEIS, which is accountable to Parliament on matters including security of supply and sustainability in Great Britain's energy sector. In light of the integration of the Northern Irish energy sectors into the ISEM, the department responsible for the energy sector in Northern Ireland is the Department for the Economy. The Oil and Gas Authority, OGA, was set up in April 2015 as an executive agency of BEIS to maximize the economic recovery of the oil and gas resources available in the UK. In October 2016, however, the OGA was incorporated as an independent government company with BEIS as its sole shareholder. The OGA has the power to regulate the exploration and development of the UK's offshore and England's onshore oil and gas, the UK's carbon and gas storage and offloading activities. The OGA also has a critical role in encouraging investment in the UK promoting opportunities to transition to a lower carbon economy and influencing a culture of greater collaboration within the energy industry. To fulfill its role, the OGA has been given a range of powers under the Petroleum Act 1998, the Energy Act 2011, and the Energy Act 2016. The Office of Nuclear Regulation (ONR), an independent statutory corporation established in April 2014, is the regulator for the UK nuclear industry. The ONR reports to the Department for Work and Pensions. However, it works closely with BEIS. The objective of the ONR is to provide efficient and effective regulation of the nuclear industry, holding it to account on behalf of the public. This includes granting nuclear site licenses, regulating the transport of nuclear materials, and ensuring compliance with safeguarding obligations for the UK. The Financial Conduct Authority (FCA) is the UK authority responsible for the regulation of firms offering financial services. By virtue of the broad definition of financial services in the Financial Services and Markets Act 2000, certain energy products are captured, and therefore a variety of electricity and gas market participants are subject to their oversight. These market participants must either become authorized with the FCA or seek one of a number of available exemptions, such as the one for transmission system operators (TSO) or for the provision of ancillary services. The FCA is additionally responsible for the oversight of the anti-market abuse regime in the energy sector. Environmental regulations in the UK is a devolved function, with England, Wales, Scotland, and Northern Ireland each having adopted a different approach. In England, the Environment Agency (EA) is responsible for the protection and enhancement of the environment. It is a non-departmental public body that is organized into 8 directorates. The Department for Environment, Food and Rural Affairs is partly responsible for the funding of the EA and is responsible for the appointment of the chairman and the board. Environmental affairs are the responsibility of Natural Resources Wales (NRW) in Wales, the Scottish Environment Protection Agency (SEPA) in Scotland, and the Northern Ireland Environmental Agency (NIEA) in Northern Ireland. As required under either the Planning Act 2008 or the Town and Country Planning Act 1990, local planning authorities (LPAs) at the borough, district, or unitary council level are responsible for consenting to energy project applications.